and that's it. The Supreme Court said, this is what it says at paragraph 31. By playing the recording in open court during jury deliberations, the circuit court can guarantee the jury does not play the recording multiple times and may instruct the jury as necessary to minimize the risk of overemphasis. So that's how I take that. So it's clearly an open court. I think we all agree on that. At least under Anderson, it can be played once, not rewound, and started and stopped. That's how I read Anderson.
State.
Anderson makes some interesting findings. In looking at Franklin, it talks about how the risk of breakage or accidental erasure of the tape, which obviously is not an issue here. What we have here are digital copies of everything. There's no risk of erasing or breaking. They can be duplicated as much as we would like. Now, I do agree that that is what Anderson says, but I think it is important to note that what Anderson says is about a statement, a video of a statement, not actual evidence. And Your Honor had a case, State of Wisconsin versus Antoine Flint, in which because it was actually a video of the incident itself, not of a statement. So Franklin is about a defendant's statement, Anderson's about the statement of a child. Here we're talking not about statements, but a video of the actual incident. And that was, you sent the video, I think it was an armed robbery, back to the jury room. It was appealed. There's a per curiam unpublished opinion.
Can you cite a case that the judge actually remembers?
That what?
I remember. This was on 75th Street. I hold up at the I don't know. It's about 43rd Avenue and 75th Street, and there was a video of the incident itself. And go ahead. I'll take the fine. This is $50.
I hope he's ready to take it too.
I don't know. You know, this is what I mean about insulting the jury. That's what we're doing. The big thing about breaking the tape, that's from the original Maurice Franklin case. I talked about it a few days ago. I tried that case right here in this courtroom. I was a district attorney, and he was on trial for murder, and he had a very small role in the armed robbery in which a man was killed. And so he was charged as part of the crime, and he had a very non-knowledgeable and stubborn attorney, and insisted on taking the case to trial without really, well, for whatever reasons. And the law was clear. It was a premeditated murder by a 15-year-old boy. And Mr. Franklin was, I think, 18. And he never even entered the building. He was a lookout. And the defense attorney stood right down there and said, the intent does not transfer from one person to another. And then the judge correctly read the instruction. It's called transferred intent, and he's guilty of any act which is a natural, probable, and usual consequence of the armed robbery. And that concluded the murder. And so Mr. Franklin was convicted of first-degree murder. Judge Morton, who is a wonderful man, who had a heart of gold, and who knew the law, granted judgment and sentenced him to life imprisonment, and commented that he hoped the case got reversed. And it was reversed for a different reason. But they discussed that statement that you're talking about, a tape-recorded statement. This was in 1974, as I recollect, right on the heels of Watergate. Rosemary Woods erased 14 minutes of President Nixon's behavior, and there was he lost his job. And so this was a big deal. And so the Supreme Court mentioned about the breakage of the tape. That's not an issue, you're correct. They also talk about exaggerating some aspect of the evidence. The defense, the state, I should say, is totally correct that the incident on 75th Street that happened more recently, what was the name of it? Flint. I admitted that because I said, no, that those rules don't apply because this is actually an image. These are images of the event occurring as opposed to a statement of the accused or a statement of a witness, which were the case in the Franklin and Anderson cases. And so I do feel that those rules are not, the rules to be derived from Anderson are not strictly applicable to the to footage from the actual event which is claimed to have been criminal. So it's not just that one case, there have been other cases that I've admitted these videos and let the jury play them. I complain about the case of, well, I don't remember the man's name, but he was convicted of attempted murder of a police officer. Well, actually, I think of reckless endangerment or something, but because of video footage that they had to come down here and watch on a tiny computer, and we had to bring them down 3 at a time because we could only let them see it one time. I think that's so outrageous. But, you know, I have to be aware. You want me to kind of just let them have what I gather what you say, although actually most of the time your office has come in here and told me, no, Judge, don't risk our case. So don't send this. What do you want me to do? What do you want me to do? Tell me.
Judge, I do not believe Anderson applies directly. I believe that because it is of all these requests are of the incident themselves, or incidents themselves, that I believe the jury should be able to watch them as they see fit, watch them, pausing them, rewatching them, watching them in any way they see fit, in any configuration they see fit. I believe that the Franklin and Anderson cases, I understand how someone's statement, a videotaped statement, could be overemphasized. I do not see how videotapes of an incident could be overemphasized or looked at too much. And really that's what this whole trial has been. While there's been lots of testimony, almost everything testified to is on video. So to me, I believe it is clear that given that it's a videotape of the incident, they should be able to view it as they see fit. Now, Anderson, again, of a statement, says it should be in open court. That certainly can be done. The jury may feel uncomfortable, obviously. So I think if the court makes specific findings as to why it's appropriate in this case to send it back, we could send it, or actually what I would propose is making the courtroom the jury room, clearing out the courtroom, checking for any devices that would be recording the deliberations. We can either give them all the exhibits and instruct them to only watch the numbers that we agree on or that are allowed, or we can put them on a separate drive, the exhibits that they've requested or that they'll be allowed to see, and they can essentially have access to all the screens here and they can play it and do it as they see fit. Now, with this distinction of it being the incident itself, if the court makes findings of why it's appropriate, the state believes that it will survive any scrutiny on that issue if there is any kind of guilty verdict.
Well, you're suggesting an abandonment of the insulting precedent of the last hundreds of years that the jury might overemphasize some aspect of the exhibit. He says it should be played only once if it's played at all. And you say play it as much as you want, which my intellect tells me is the best way, because as I talked about the Tsarnaev case, that's how it got solved. And it seems to me this is a pursuit of truth, and you should take the course that you think will lead you there. And if the jury thinks they want to look at it 80 times and they want to talk about it and criticize each other for their respective views of it, I think they should be allowed to do so without interference on our part. That has not been the law in this country, which, in my estimation, treats jurors very poorly. And so I don't know, your office, this is the first for me that your office is agreeable to this. But that doesn't mean you can't do it, because you can.
And usually, the only time I've ever encountered this issue, I can't speak to everyone that's been in my office the last few years. The only time I've ever encountered this issue with you or any judge, I believe, is because it's a statement. And the video of the incident is different. So, and what the court must weigh is whether the exhibit will aid the jury in proper consideration of the case, which you and I at least agree, whether a party will be unduly prejudiced by submission of the exhibit, they've already been submitted, and then improper use. I understand how, especially a statement of a child or a statement of a defendant being reviewed over and over and stopped and rewound, how that could be an issue. But of an actual incident like this, which is what this whole trial has been, is showing videos of the incident. And I think it is fair to this jury and fair to the process and frankly fair to the defendant if they're able to see the videos as they see fit. So we can either give them, if the court adopts this, we can give them a drive with the acceptable exhibits. They can play them. They could have access to the court technology if everyone is kicked out, and it can continue as that. I don't know if the court can allow that with its calendar, but
this is more important than anything I've got on the
so
calendar.
the state's position is that Anderson is very strictly relevant only to a statement of a witness or defendant.
By the way, what about, I now have had the chance during the break to read the defendant's motion for dismissal,
Yes.
and there are allegations made there about the material that was provided to them.
Yes.
Certainly if I follow through on what you want, I think I warned the other day because I was queasy, very queasy about this particular exhibit from the drone, and we exchanged a lot of emails over the weekend about it. And I think I warned you the other day that you're putting an awful lot of emphasis on this, and if it turns out that it's not technologically sound, I've referred to it as the situation as a house of cards. This is just more weight on that. If I now allow them to review it without restriction as to the number of times,
Judge,
you're comfortable with that?
we are. Now, if I can respond at least to that portion of the motion to dismiss, it's factually inaccurate. So let me go back to the first Friday of trial. Mr. Lukowski was testifying. In the middle of his testimony, I got a notification that there was someone at our office who was refusing to give his name with a drone video. This drone video was shown on Fox News a couple days after the incident. It apparently was on the internet briefly and then taken down. The defendant's first attorney, Mr. Pierce, appeared on the Tucker Carlson show and discussed the video and seemingly brought the video. We've been told since then by the person who took the footage that they've sold the video to Fox News. Now, we've had a poor quality of this video the entire time. It's actually in Exhibit 41, which the defense submitted. On Friday, the individual who took the footage, who had been unable to find, came and airdropped the footage to Detective Howard. Airdropping is a way that it just goes from phone to phone. It doesn't go through text messages or email. It has to be iPhone to iPhone. So in the middle of Mr. Lukowski's testimony, I asked Mr. Howard to go and our investigator to go speak with this individual and see what he had. I suspected it was this video from the Tucker Carlson show. It was. Detective Howard got a airdropped copy. He brought it into court. As soon as the next break happened, which I believe was just minutes after he arrived, as soon as the next break occurred, which I believe was just minutes after Detective Howard arrived, I took all 3 defense attorneys in the back to discuss a couple of issues which are not relevant, and I also indicated that we now had a much better quality drone video. Detective Howard asked them how they would like to receive it. Ms. Wisco asked that it be emailed to her. He emailed her the file. Now, somewhere along the lines, whether it was, it appears the issue is, I believe Ms. Wisco could not have an airdrop because she has an Android phone. Going from an iPhone to an Android, it appears somehow compressed the file.
Was she made aware of that? Because I have an Android phone too.
We did not know that this would occur. If I knew how to compress files and knew all this technology things, I'd have a much better job. So this file was given to us. We gave what we fully believed was the full file to Ms. Wisco. It was admitted to evidence. It was the authenticity was stipulated to. It came in without objection. We've heard many times this trial how there was no objection. It was an exhibit for 4 days and played and shown to the jury and on the screen for 4 days. And then on Friday is when I think we all discovered that something had happened to Ms. Wisco's file. She played it on the big screen. It clearly looked different than the copy we all had. I believe we offered to airdrop it to the other attorneys, and I think it was declined because they didn't know how to use airdrop. And then we got her the full copy. We cannot be held responsible for the software on Ms. Wisco's phone. We didn't compress anything. We didn't change anything. That would have been something that happened in the transfer that we had no knowledge of. We of course did not mean to give them a different copy, and until Friday when Ms. Wisco played it and it looked different than what we've been looking at, we had no idea it was any different. And then when requested, I gave her, so what I did is I took an email from Detective Howard. He emailed me the file. It was not compressed. I don't know, probably because it's Apple to Apple, or I was using Gmail at the time. It was the full, as far as we know, the only copy of the video we were ever given, the only copy that's ever been had, and then I put it on a thumb drive to give to the State Crime Lab. So I cannot explain why Ms. Wisco's file had been compressed. That is not something that we can be held accountable for. We didn't know it. We don't, and if Ms. Wisco knew it, it wasn't brought up until Friday. Now, there was some dispute Friday about there being different copies. There was no different copy. The software on Ms. Wisco's phone, or whatever software she used to view it, compressed the file. The only compressed file is the one Ms. Wisco has. All the ones that we have seen, and we did not alter the file. None of us know how to alter the file. None of us know how to compress the file. We wouldn't have had time to do so. You can probably go back on the footage and see when Mr. Howard, Detective Howard brings it in, and while Mr. Lukowski is being questioned, we're looking at it to see if it's the drone footage that apparently the defendant's first attorney had or was aware of. And I understand he's different attorneys now, but this is still the defendant's attorney at the time knew of this 3 days after the incident and was talking about it on national television. So to somehow now accuse us of compressing a file and somehow being able to do this technical wizardry to somehow sabotage the defense is preposterous. The defense saw this video and thought highly enough of it that they went and bought a large television that is now being used in court because they wanted to show it. And now all of a sudden to come back and say, well, we had a bad copy, they could have checked, they could have asked for a thumb drive. They could have asked for whatever. As far as we knew until we had this hearing on Friday, everyone had the exact same copy. And that Ms. Wisco's phone compressed it is not our problem. It's not, we're not responsible for that.
She can go to her phone.
If I may.
Well, no, one at a time. One at a time. Well, why don't you start, Ms. Wisco?
Can you talk into a microphone? Yes. On November 5th, 2021, I received at 10:33 a.m. an email from Detective Martin Howard with one video file attached. It was a 4 millibyte video that was titled IMG_0159.MOV. I have never looked at that video on my cell phone. As soon as I received that video via email, I downloaded it to this laptop, which is the evidentiary laptop we've been using through the duration of this trial.
What manufacturer is that?
This is a Lenovo.
Okay, go ahead.
And I relabeled it after it had been brought into evidence by the state as Exhibit 73 because it was Exhibit 73 for ease for bringing it up, showing it to the jury. After we found out in Friday that there was this discrepancy after the videos being shown, and for the record, we did not buy that TV because of this drone video. We actually brought it in for John Black's slowed down testimony. That was the reason we brought this TV in. However, when we were in court, I played the Exhibit 73 on my computer because the state's computer wasn't here. ADA Kraus was the one who brought up the fact this isn't the good quality video. We didn't realize until playing them side by side, mine and then the state's, that there was any difference in quality. That was Friday. After Friday happened, I emailed both Binger and ADA Kraus, and I asked for an exact forensic copy of what they had given to the state crime lab. ADA Kraus responded back to me, forwarded me the email he's talking about to Detective Howard, and that also contained one file named as IMG_0159.MOV that was a 4 megabyte file. Simultaneously, ADA Binger had been in contact with me, told me I could come pick up the file from a flash drive. I drove here, I had him take me inside, and I confirmed that this file that he said was directly provided to the state crime lab was an 11 megabyte file, not 4. So the information contained in the flash drive was over double the size, almost 3 times the size as to what was emailed to me. When ADA Kraus followed up to me with that email, forwarding me his email from Detective Howard, it was the same 4 millibyte file that I had gotten previously.
So clearly Attorney Wisco's email is compressing these files. That's not our responsibility. Oh, I didn't write Outlook software.
You know what?
I forwarded
Well, wait a minute. I don't know if she had finished.
Every other piece of evidence from the state crime lab in this situation has been provided to us via Dropbox. Dropbox provides an exact forensic copy of what they have. The file title name in this situation should have been exactly the same as the one provided to the state if it was the exact same copy. The file name was nowhere near similar. The one that was provided to the state's crime lab that Attorney Binger gave me a copy of on Saturday had a very long, convoluted title that involves lots of letters and numbers that are the type that are usually associated with files taken from a drone because they indicate a lot of different information like the location of the drone and the time. The file I received originally on Friday the 5th was not labeled that same and was not the same file amount. There's no way that what ADA Kraus is saying is true because the file name would not have changed if my computer was compressing anything. It was a different file that we were provided from what was provided to the state, at least for what Attorney Binger gave me on Saturday. They're completely different.
I think we're confusing the issue here. The work product Dropbox. That's how they've submitted all the videos that they worked on and the photos they worked on. The email from my personal Gmail account is the file that went to the state crime lab. I was told to bring it to the state crime lab. I was already home on Saturday. I did not have access to anything but my computer. I had Detective Howard email it to me, and I put it on a thumb drive at home, and I took it to the crime lab. I don't know if Mr. Binger somehow retitled it, but the image I gave the crime lab is on my phone as the title that she indicated. That was the one that went to the crime lab, and I will testify as an officer of the court. I take offense that what I'm saying is untrue. Clearly,
Well, we're going to
My-
obviously we're going to have to take this testimony under oath, and we're going to have to get somebody to explain all this, who has some competence. Which
If you look at the report from the state crime lab, they indicate the originating file that they received was the one with the expanded title that we did not
Right.
receive until Saturday. If it had been the same file as 88 Kraus says it is, why wasn't that labeled on their receipt as being IMG 059 or 159?
Mr.
If that
Kraus,
is the exact same thing, then that does not add up.
Mr. Kraus.
Why did he include in his report a different title?
I'm looking at the email. It is image0159.mov. When it's downloaded to computer, perhaps it has a different title. On my phone and on my Gmail, that is the image. I'm watching the video right now. This is the precise one that was given to the state crime lab. I had no other access. At this point, the first time this was ever put on any kind of hard drive is when I did it Saturday at my home. And I'll do a little experiment here. I'll save it to my computer and see if the title changes. But
We're going to do this. Pardon me?
I accidentally saved it 3 times because I was trying to re-download it
Yeah.
multiple times, and it all saved it as IMG 0159.
Okay. Well, you know what? We can't resolve this now because this is going to require expert testimony from people, and we're going to have to take testimony under oath as what the facts are, and so that I'll reiterate my comment, which started this discussion, which was that given the cloudy picture about this particular exhibit, yeah, this is a high-risk strategy for the state. I was queasy about this from the beginning, and I'm only queasier about it now.
Judge, what we propose is to show the jury the exhibits. I'm really not concerned about the image. As I've said multiple times, I believe much too much has been made of this image. Mr. Binger didn't even mention it in his closing. We didn't show it in either our closing or rebuttal. The other evidence was admitted without objection with a stipulation to authenticity, and I believe it should be played. It's already been played for the jury, and they should be brought down, and we can put all the other exhibits on a thumb drive outside of 160, what is it? Outside of exhibit 155, which is the image that the court is received over objection. But the other exhibits were not objected to. And again, the defense, although a prior attorney, had access to this video 3 days after the incident. So to now claim that they are somehow prejudiced is preposterous. I understand it's previous counsel, but it is still the defendant's attorney. He was charged with this crime, and if Attorney Pierce did not turn something over that he had and that he seemingly brought to the Tucker Carlson show, that also is not our responsibility.
Your Honor, can I briefly respond to that?
Yes, sir.
Mr. Pierce was my client's attorney. As Mr. Kraus said, Tucker Carlson purchased that video. That video is very different from the video that was delivered here in quality, color, there. We stipulated to the video based upon what they gave us. We didn't see it as anything different. We were given.
I want to stop you now.
Okay.
Because why do you say that the one that Mr. Carlson bought, Tucker Carlson bought, is different from?
Black and white.
That was okay. Go ahead.
And we stipulated to that video when we looked at our copy because it didn't add anything except color. We didn't have the quality. And that's where this whole problem starts. And we weren't aware of the quality until after the evidence had closed on Friday, when we were here and it was plugged in as Ms. Wisco was saying. That's when we found out there was a problem, what had been given to us versus what they had. That's when the whole problem comes up. So that's as to that video. The other one, and I'll just say it because it's going to be an issue, FBI aerial with all POI'd marked. That, when we're going over this list, it's come to my attention. I played that for the jury. It never got marked or moved in, even though it's been played.
Are you kidding me?
I am not kidding you,
Can we
Judge.
put it in evidence now?
That's what I think would be the proper way to do it.
If the defense agrees that all the drone videos go back, we will agree that
I'm
that
not
should be
going to
marked
run a
into
compromise.
evidence.
This isn't, let's make a deal here.
Well, they did not mark the evidence. They did not move it.
But it was played to the jury.
Yes, and not marked or moved.
I thought it was part of the hard drive that everything was going in.
And I thought we gave them a full and complete copy of the video. So.
Well, I'm going to reopen the evidence and admit what they saw. Give it the next sequential number.
Well,
How can I not give it to them? You tell me.
I mean, then I would ask that evidence that's been admitted also go to the jury, that has been legally admitted in front of the jury, and follow the proper procedure.
Let's take one thing at a time.
Your Honor, just for the record as well, there was an additional difference that we found in the metadata between the two videos, is that if you look at the metadata from the file that we received from the state, is their create date is 11/5/2021 at 15/10/31. If you look at our video that we were provided, the metadata, the create time is 21 minutes and 19 seconds later.
Judge, we're looking at the Tucker Carlson interview with Attorney Pierce. It is not black and white, it is color, and it actually does seem to be high definition, like this video. We're watching, it's online, you can watch it.
What I have is black and white.
Mr. Rittenhouse's attorney has seen the real version.
What about that? If his prior attorney, he's got it.
I don't know. They said that Tucker Carlson bought it. And that's what goes to this whole thing, this urban air. We sent out an investigator to interview the owner of Urban Air to try and get this video. And I can get the report, I don't have it with me. And the individual lives out in the Lake Geneva area. And he lied to our investigators and said, we are mistaken that the drone permit wasn't for this video. And now it's come from his company. He shut down his company 17 days after this video was released. We've tried to get this video, and then it shows up on the Friday after the trial has started. And it's dropped off by his employee, not the person who we interviewed who owned the company.
I don't know who was interviewed. I believe that is the owner Mr. Beeman? Oh. Okay.
I'm shaking my head no. I answered no to Mr. Rouse's question. I apologize.
Well, this is number 5, and they say, please prepare. And then it lists these things, and then it says, we will request when ready, and they haven't followed up. So I'm playing short. Maybe the ball won't come to me.
So, well, if we're moving on, at least for the moment,
Let's move back.
let's go to number 4.
Yeah.
So, it seems that the request, it says view video, but I believe it's actually, 3 videos.
I did not hear you, sir.
It asks for a video, but I believe they're actually asking for 3 videos, and I think we agree on this, that it asks view video starting with Mr. Grosskreuz's interview with Mr. Rittenhouse. That is Exhibit 3. It's also duplicated as Exhibit 57. That is the live stream that Mr. Grosskreutz took that night. That does not actually depict the second incident. It does, you can hear the shots, but then it asks to 10 seconds after Mr. Grosskreutz shooting. I believe that's what's referred to as the BG on the scene video, which is number 5. And then it indicates in regular and slow motion. The only slow motion of that incident is the BG on the scene video, and that was the one that Dr. Black created and played. That was moved and admitted. It does not formally have a number because it's on a drive. We do not object to it being given a number and sent back, or well, played however the court deems appropriate. So we would ask that. So I believe there's 3 exhibits they're requesting. The state does not object to them having access. However, it is deemed appropriate to those exhibits.
All right. So, and that's by agreement. And then the question is where and what restrictions will be put on their use of those videos.
The state's position is that they should be given the exhibits or told what numbers they are. The courtroom should be cleared. They should watch them on the monitors they've been watching the whole case on. And that can be set up, and then everyone can leave, and they can discuss it. Now, it says...
All by themselves, or...
By themselves.
Okay.
Just as they
I
are in the jury
assume
room.
that somebody has got the technical ability to trigger playing of the videos.
That's a fairly simple process. They can be given a computer with you just plug it into the side, and then they can just press the thing. If there's...
Computer, it doesn't have other matter on it.
We have, I believe our computer, if it doesn't have anything else in this case, it may have like Microsoft Word or something on it, but there's no other evidence of this case on it. It's not my computer. It would be we have some standalone laptops to do this type of thing.
What's the defense position?
We were talking about it, and the question that I have, and I don't have an answer because it wasn't in any of these cases, is there any right, if we're doing it in court, is there any right for Mr. Rittenhouse to be present?
More than if they had paper exhibits and they were discussing them. And certainly the defendant can't be in the room when they're talking about them.
Well, I agree
Why
with that.
is the video different?
Well, if you clear the room and say this is now the jury deliberation room, which is what they've asked.
No. I want to go back a step.
Okay.
Supposing I said, well, let's just get a computer that has nothing else on it, or that everybody feels it's sufficiently sanitary, and let's put these exhibits on a flash drive or download them onto the computer or whatever, and then send that. upstairs. Let them do it just like they would if they were paper exhibits, and they can play it and discuss it as much as they want. Now, I'm talking right now only about question number 4, because there's other issues with respect to question number 5, and fortunately, they're not here yet, because they haven't requested it. But this would be a departure from the Anderson case for sure. That would not be incompatible with what I did in the Flint case. Flint. Who's okay with that?
I'm sorry,
Who's okay with that?
we are okay with that.
Is, based on what you've said, so we're not waiving anything on 5,
You're not waiving anything on 5.
then that's okay for 4.
Okay, now we just need to get a clean computer. And you say you have some available, Mr. Kraus?
We can, this one,
One of those?
I have to look at it, but it can be clean.
We'll look at it. Well, I'm going to go and do something else. I'm not going to go. I'm going to stay. I'm going to stay and do something else. And I'll let you fellas try to work this up. And
At this point, Your Honor, they have not requested what we're fighting about.
they have not requested.
At this point, they have not requested what we're fighting about.
You are correct.
Okay.